a residential lease agreement for your home that you're getting ready to rent. We're going through the lease for you at this time. And if you have any questions, you're welcome to ask the leasing agent once I'm done with this for your information. This is a lease agreement in Charleston, South Carolina between you as the tenant and our office, Daryl Shorter Property Management, as the landlord. Now, we are located within Dorchester County, but your property will be located in one of three counties, either Berkeley, Charleston, or Dorchester counties, and that'll be indicated on your lease. Now, we are licensed in this state as a licensee of the state of South Carolina. This lease agreement will go in accordance with the South Carolina Landlord-Tenant Act, defining your relationship as the tenant to our relationship as the landlord for your property. And the lease agreement that you're signing is the specific contract for the home that you will be renting. The property is under item 2 as the location, that is your street address of where you'll be living. The terms of the lease commence on the date indicated along with the ending date, which typically is a year lease. Any extension that is agreed upon or entered into would be separate in writing. Otherwise, when you go to vacate the property, you are agreeing to return the property to us free of personal possessions, clean, returning the keys to us, and providing us your forwarding address as well. Now, we are holding a security deposit on your behalf. It is an interest-bearing trust account that we will be maintaining throughout your occupancy. At no time during your occupancy can you or we touch the security deposit. So, for example, if you're short on rent on a particular month, we cannot use these funds towards your rent. It is strictly the security deposit during all times while you're occupying that particular home. The property is being given to you with keys that are indicated within the bottom of section 4. That indicates any keys that will need to be returned to us when you go to vacate the property. If your home was built before 1978, we'll also include a lead paint addendum, and that is a separate addendum agreement which our leasing agent will go over with you at that time. Now, we have approved your occupancy in this home based on the rental application that you have provided to us. Should we ever find throughout the lease that you were purposely withholding information or misleading or falsifying the application, that could be grounds for terminating the lease, just an FYI. Your monthly rent is indicated as payable per month, that is due on the first of each month. The address in bold is where you can mail the payment. You can also do a direct deposit. You can set up an e-payment. You can mail us a payment as long as we get funds in here which are due on the 1st. Now, if you'll notice in bold at the very bottom of page 1, we will not contact you should your rent become late for a particular month. This lease agreement is notification to you that your rent is late. So we will automatically be filing an eviction action, typically around the 6th or the 7th of each month, depending on how it falls with holidays and weekends, in order to properly notify you that the rent is in fact late and due at that time. So if you look over page 1, that's the gist of what we have on page 1. And we will go on to page 2, which immediately jumps into the late fees. Now again, your rent is due on the 1st. You have a grace period through the 5th. On the 6th, your rent is late. It is a 10% of your full rent amount late charge in order to clear your account. So that will automatically be applied on the 6th of the month. If you pay by personal check, not a problem, absolutely fine. However, if the check comes back to us due to NSF, insufficient funds, then there is a $30 return check charge, which will be in addition to the rent, which will be in addition to the late fees that will be due at that time. If you file us a NSF check 2 times during your occupancy, after the 2nd time, no longer will we accept personal checks. It'll have to be money order, certified funds, or e-payment through our website, DougShorter.com. The occupancy of your home is indicated under section 9. At no time can you have more than the number of people indicated within that section living in the home. The renewal terms under section 10, if you provide us a written 30-day notice when this lease goes to terminate, you can end your lease. So for example, if your lease is ending the end of July of whatever year, then the very beginning of that particular month, beginning of July, you would need to provide us a written 30-day notice. Now, this lease automatically renews month to month. If you have not provided us a written notice and we have not provided you a written notice. So this initial lease term would expire, but the lease would remain in place because you have a month-to-month occupancy based on the verbiage that's in Section 10 of your lease agreement. We, with a 15-day written notice, can give you a rent increase to your property once the initial lease term has been successfully completed. So just be aware, with a 15-day written notice, we could increase your rent based on fair market value and owner input as well. You cannot sublease the home to anyone. If you have anybody that will be staying in the home 10 consecutive days or greater, that could be constituted as subleasing. It is an excellent idea to call our office, notify us if you have guests in town, family members, whatever the case, because we certainly don't want to violate the sublease clause within your lease agreement. Unless utilities and services are provided within the lease, there are no utilities and services that we would provide. You would be responsible for those on top of your lease obligations that you have. But if we do, then any hookups or disconnect charges as a result of non-payment could be an expense that you would incur. So just be aware of that. Now, there are certain responsibilities that you are obligated to uphold during your lease. One of them obviously is maintaining the property, making sure it's clean, safe. If you bring hazardous or contagious materials to the property, it is your responsibility to have them removed. If you damage anything within the property, then it is your responsibility to notify us. It is your responsibility to notify us if there's any potential problems with the home. A very good example is if there is a ceiling stain. That is an indication there is some type of an active leak. It may not bother you at that time, but that ceiling stain could get larger over time, and at some point potentially that ceiling could collapse. Well, if it were determined that you knew about this and failed to report it, you could incur some of that cost, if not a majority of that cost, because that damage could have been prevented had you simply notified our office. So it is your responsibility on any issues within the home to notify us that there are issues. Any careless use or negligence of the properties resulting from theft, malicious mischief, or vandalism by you, relatives, guests, anybody coming into the property, that would be your responsibility. If you do have any type of theft, vandalism to the property, it is your responsibility to obtain a police report and provide our office with a copy of that notification. It is your responsibility to take care of all routine issues, and this includes, but it's not limited to, light bulbs, smoke detector batteries, changing that AC filter, checking for plumbing stoppages that you may have caused, especially in a toilet or possibly in a sink. Notify us, though, if there are any other issues, especially water leaks, electrical, heating and air, things of that nature. You are responsible for any damages caused by your equipment being brought to the property, furniture, appliances, anything that you bring into the property, any damages that could be incurred, you would be responsible. Now, prohibited items, water beds, trampolines, let me look here, satellite dish, auxiliary heater, or an antenna. If you plan to bring or install any of those items, they're basically considered prohibited items. You need to seek separate written authorization from us in order to get authorization for those particular items. You are responsible for changing the air filter. Typically it needs to be changed on a monthly basis, and that way you're keeping the unit free of any potential clogging to allow that unit to keep clear, so your air unit can breathe. So it is your responsibility to keep that air filter changed. We recommend typically on a monthly basis to keep that filter changed on your behalf. And outside, the unit that is outside, you want to keep the grounds clear, no weeds growing up within that compressor outside, making sure the weeds are down, no buildup of dirt, ant piles, pine straw, anything of that nature which could clog that system outside and potentially damage it. It is your responsibility, unless indicated in Section G on page 3, to take care of the lawn during your occupancy, and this includes the beds free of weeds, replacing mulch as necessary or pine needles, trimming the shrubs and trees, and keeping the property free of debris from fire ants as well. Smoke detectors, we are providing you with smoke detectors, one in each living area, one in each bedroom, and one in each level of a particular property. So for example, if you're in a 2-bedroom single-story property, you would be given a minimum of 3 smoke detectors. So we're providing those for you for your convenience. It is your responsibility to make sure, as I previously mentioned, that those batteries are maintained on a continual basis. You don't want those to die and then your smoke detectors are no longer usable. So be sure you do take care of that on a continual basis. Unless in section I that we've indicated that the landlord is responsible for pest control, you as the resident typically would be responsible for any type of pest infestation after the first 3 days of your occupancy. So if you do notice any type of an infestation, and no, one bug does not constitute an infestation. So please do not call us if you just see one bug. But if you're seeing several throughout the home, that could constitute infestation of the property, and we will provide a courtesy spraying for you free of charge, again within the first 3 days of occupancy. After that time, it is your responsibility for pest control. Now, if there's adverse weather, typically in the wintertime going below 32 degrees on several consecutive days, or during the summer months, possibly high winds are expected, heavy rains, whatever the case, it is your responsibility, and we respectfully request that you take care of whatever needs to be done to address any potential problems. And we're talking about securing items outside, prepping your windows, etc. That is not a service that we would provide, especially in the hurricane season, in order to prep your home. So if you have any questions in that aspect when the time arises throughout the year, certainly call our office. We'll be happy to go over that with you. But when we get below freezing weather and it's a deep freeze, we would ask you to drip the pipes, because the properties here in the low country are not geared for really cold weather on a long-term basis. Now, mold or mildew is common within the low country. That is basically the presence of moisture, and it is growing. It is very common within a bathroom area and potentially around the sink in the kitchen. Mildew, you simply clean it with mildew chemical issues that would take care of those for you. Mold is a little bit different. As you know, there may be quite a variety of mold that could definitely be within your home. It's the high concentration of mold that is of concern. So what I'm getting at, if you have mold or mildew within the bathroom area, within the kitchen area, please take the necessary steps to clean this on a continual basis. However, if you're seeing mold or mildew abundant, growing, black areas, if you will, notify our office. That could be something a little bit more significant than your typical mold mildew cleanup on a regular basis. So make us aware if you do have mold mildew issues. We will do Section 15, what is necessary to keep your property safe and habitable during your occupancy. This regards the necessity issues on a day-to-day basis. As I've already mentioned to you now twice within this lease, we are not responsible for checking your garbage disposal, for checking for trip breakers, checking to see if your air filter is clean, placing light bulbs, replacing smoke detector batteries. Those are tenant obligations. If we have to come out to the home to take care of a repair and the breaker was tripped, the garbage disposal reset needed to be done, that could be a charge that you would incur. So please check those items before you notify our office. Pay special attention to Section 16. This indicates the items that we are providing during your occupancy. If it is listed as a convenience item, it will not be maintained by us as landlord or the owner of your home. A typical example is the washer dryer. If you have a washer dryer in the home or any appliance that is a convenience item, should it break down, it is your responsibility to repair or replace it, because they're basically there for your convenience. We have liability insurance as Daryl Shorter Property Management, Inc. The homeowner has homeowner's insurance. You are strongly recommended to get renter's insurance. Should anything ever happen to your personal possessions within the home, theft, damage from something being caused within the home, plumbing leak, whatever, your personal possessions are not covered. So we strongly do recommend that you get renter's insurance. Indemnification clause within Section 18. You are not holding us responsible for any injuries that you could partake in at the property. If you have not fulfilled the lease, if you have not notified our office, If a member of your family, friend has come over to the property and there has been some act or omission that you have partaken in, you are not holding us responsible for those particular acts. Any requirements imposed by the government authorities, any judgment, lien, or encumbrance that's filed on the property as a result of your action or damage or injury happening to the property by you, your family member, friend, and invitee, failure to maintain the property per the lease agreement, basically all of those you're indemnifying our office of responsibility in that aspect. We will move on to page 4, which is section 19, right to access. You are being guaranteed enjoyment of the property through your lease. However, there are certain times that we can and will be coming into the property. A few of those times would be without notification. One of the main issues would be in the event of an emergency. We see something of significance and we have to gain immediate access to the home. That is under the emergency section. We can also come in between 9 a.m. and 6 p.m. for routine services, including routine inspections, which we do perform at least twice per year, along with drive-by inspections where we may set foot on the property just to inspect the exterior of the home. However, on the routine inspections, you will be notified within at least 24 hours notification that we are coming in. And between 8 a.m. and 8 p.m. during Monday through Friday for services that you possibly have requested. The other times that we can come in with notification, typically a 24-hour notice minimum, is in the event that the home is being shown for future prospects, either for sale or for rent, or if you're being evicted. And at that point, we will be with law enforcement and a constable to gain possession of the property. And if you have personal possessions in there, we will be forced to remove those from the home. If you're active military, pay close attention to section 20. That is the military clause with a copy of your transfer orders and a written 30-day notice. We can release you from obligation for the lease agreement. If you're given notice to transfer out of the area within 30 days, that's understood. However, you are still responsible to provide us a written 30-day notice to vacate the property, and again, along with those active transfer orders, and that will release you from obligation for the lease. A 30-day written notice is defined as any notice that is provided in writing from our office to you or from you to us. And that is once it is received by either party, not when you send it, but once it's actually received. So that is when the action would take place, starting from that 30 days that it is actually received from either party. If the property is damaged or destroyed, and you cannot use a portion of the property or the property in its entirety, within 7 days of that event occurring, you need to notify our office in writing as to your intentions. And the reason for this, if there's prorated rent that has not been credited to your account, or there's a security deposit in play, we need to give that back to you immediately. That's where basically if you cannot use the home in its entirety. But we cannot, under South Carolina law, disperse any funds to you without written instructions. That's why we need that in writing. And we can take email, fax, you can hand deliver it, you can mail it. Any of those methods are acceptable. If there is an issue at the home that you caused, a fire is a very good example, and it completely destroys the home, then the security deposit, you're not subject to getting refunded. There probably will be additional charges that will be incurred to your account in the event that you caused whatever action to occur at that property. This section calls towards any accidental occurrence to the property or basically any issue that you did not cause during your occupancy. If the property is condemned or it is foreclosed upon, you do have rights within the state of South Carolina. Someone cannot just show up at your door and say you have to vacate. However, if you do need to vacate, our office would be involved. We would instruct you as to your directions at that point. If it is condemned due to structural failure, you will need to vacate immediately. Otherwise, other issues of condemnation or foreclosure, you have a minimum 30, maximum 60-day notice to vacate the property. And of course, the security deposit will be handled in accordance with the lease agreement regardless of these particular issues taking place during your occupancy. Now, if the property is subject to a foreclosure or a tax sale, that in no fashion releases you from obligation from this lease agreement. So I strongly recommend, if there's any question whatsoever, you contact our office. We'll walk you through whatever problem that potentially is existing. If you're absent from the property, if you're not using it, or if you have abandoned the property, there are several criteria that would qualify the property under those circumstances. Basically, you've not paid your rent, we cannot get a hold of you, utilities have been shut off. If this activity has been going on for 15 or more days, then basically you're not living in the home. Under that scenario, then we could take possession of the property through abandonment. If you have possessions in the property, $500 or less in value, we could seize it, attempt to sell it to repay the owner lost monies on your behalf. If you're not in compliance with the lease, or if you have failed to pay the rent, we can give you a written 14-day notice to return to compliance. It will clearly identify the steps that you need to take to again be in compliance with the lease. If it is failure to pay the rent, then that non-compliance issue will be in the form of an eviction notice, and that is handled through the magistrate in your particular county. Back to the 14-day notice, it will instruct you as to what you can do, and of course there are several steps at that point. If you're in full compliance, then you're back in agreement. If you don't comply, under an extreme circumstance, we could extend the deadline. We could potentially charge you for whatever repairs need to be done to the home, or under an extreme scenario, we could terminate the lease. So pay special attention to any correspondence that is received from our office. Now, if there are monies that are due to our office after you vacate the property, we could file it against your credit, and we could come after you for collection actions, court costs, attorney fees, anything that would be an expense on our end to try to collect these funds that are due to the owner on your end after termination. Let's see. And Section 27 talks as to the early termination with notice. You are basically still responsible for the lease. However, we would take possession of the home and attempt to market it on your behalf to put a new tenant in there to fulfill the lease agreement that you have entered into with us. There would be costs associated with that. Section 27 talks to those costs on page 5, and we also have a separate addendum that we could give you an early release agreement, which would further talk about those obligations as well. So it is best to not terminate your lease early, but in the event that you absolutely have to, there are steps involved in order to do that on your behalf. Moving on to page 6 now. Notice is defined as, we've already talked about a 30-day written notice. Notice is defined as what's delivered to our office, place of business, or to you at your place of residency. You're waiving the right, Section 29, of putting us on notice of any type of a violation of the lease or non-compliance of the lease if you haven't told us what the problem is. You have to physically notify our office as to a problem in order for us to be held responsible for that particular repair. Now, we are granting you peaceful enjoyment of the property without hindrance or interruption, with the exception of right to access, which we've talked about earlier. The provisions of this lease are binding upon and ensure the benefit of us as the landlord, you as the tenant, and either party's respective successors, legal reps, or assigns. Subordination: if the homeowner defaults on the mortgage and the bank takes possession of the property, that basically is subordination. At that point, we don't represent the bank. We don't represent a third party. We only represent the owner. That would nullify this lease agreement. That would nullify your obligations with us as a resident of the property. But again, you need to notify our office should this become a question, and we would instruct you specifically as to what you need to do in order to fulfill any obligations on your end and your rights should this apply. Section 33 talks to your security deposit. As I mentioned earlier, it will be held in an interest-bearing trust account throughout your occupancy. Our company will be gaining interest off of your security deposit. You do not have access to the interest. You only have access and rights to the security deposit upon vacating the property, and that would be dispersed per the lease agreement in the Landlord-Tenant Act. Rules and regulations. There are certain rules and regulations that are within the lease, and we'll give you an addendum as well to talk about additional rules and regulations, and you would need to be in compliance with HOA rules and regulations, and should your home be within an active HOA community, we will give you a copy of those before you leave here today. You cannot make any permanent changes to the home under alteration, Section 34A, without prior notification to our office and authorization from our office. All of our properties are owned by private owners, so it is our office's responsibility to gain permission from that particular owner. So there is a process that needs to be involved in order to allow you to make a permanent change, but you cannot do that without, again, that particular authorization. You cannot make any deductions from the rent should we allow you a permanent change to the home, unless that is in writing from our office once again. You are prohibited from changing your locks, adding to the locks. If we grant you authorization to rekey any of your locks or change them out, you must immediately provide our office with a copy of the key. Again, the HOA, if you have an HOA, that's in section C, and we'll give you a copy if we have indicated that there is rules, regulations within the community. And if you're in any violation with any of those rules, regulations within the community during your occupancy, and the HOA fines that particular property, you will incur that fine. So please make sure you're in compliance with the lease, the community ordinance, and the HOA as well. Any vehicle on the property has to be roadworthy, has to have current registration, current insurance. You cannot park any vehicles that are not roadworthy. You cannot service your vehicles on the property. We ask that you don't wash your vehicles on the driveway, because that could cause premature wear to the driveway or to the grounds of the property as well. And we certainly want to limit that at all costs. So moving on to page 7, we do ask that you hang any pictures in your home with the standard lobster claw picture hook. It puts a very small nail into the wall. We ask for no large nails, screws, adhesive anchors, anything that could cause damage to the walls, that would cause prep work basically for painting those walls when you go to vacate. Pets are not permitted unless you have a separate pet agreement authorization within this lease. Those arrangements will already have been made. The leasing agent today can go over that with you if there's any question on the pet authorization. It is your responsibility to keep all utilities and services on during your occupancy, especially gas at your property if gas is provided. This also applies to the checkout inspection. In order for us to properly conduct a checkout inspection of your home, power and water must be on at the time of checkout. If they are not, you will incur a $25 reconnect fee for us to properly inspect your home. So all times, utilities must be on during your occupancy. We will provide you today with a move-in inspection report. Within 7 days of your taking occupancy, we ask that you fill this report out in detail, sign it, an initial on each page, and return that to our office again within 7 days. We will look over those, make additional notes if necessary. We will also sign it and return a copy to you for your records. That is your move-in inspection report, and that will protect you in the event there are any deductions that are made when you go to move out. That is what the condition of the home entailed when you took occupancy. We will provide a move-out inspection when you go to vacate the property. And that will be done within 3 business days of your notifying our office that you are ready for a move-out inspection. Those inspections can only be conducted Monday through Friday. Our office hours are 9 to 5. A move-out inspection can take up to an hour and a half, so 3:30 in the afternoon will be the absolute latest that we could schedule a move-out inspection. We do not make these inspections on holidays or on weekends, so please do not request that. If your lease ends on a holiday or a weekend, our office will, within the next 3 business days, conduct that move-out inspection, and you will not be held responsible for those days unless you are maintaining the property with possession still in there after your expected move-out date. Joint responsibility does not occur here. It is strictly lease in your name or you and your spouse, or whatever arrangement that has been made per your lease agreement. Section 36 in bold is our company address for all correspondence, including our office phone number, our fax number, and our company email. This entire agreement is binding between you as the tenant, us as the landlord. Non-reliance clause talks to any promises or obligations that have been made verbally by our office, an agent that potentially showed you the property, or anybody that you have discussed this property with. Any promises that are not written into the lease agreement are not binding. So make sure that what we're signing today is what is your understanding. And if there are any conflicts, then certainly notify the leasing agent prior to signing this particular agreement. Property management clause. We are the landlord, Doug Shorter Property Management. You are the tenant. This is managed for an owner. All communication regarding your lease, regarding your occupancy, is to come through our office. An owner on occasion may wish to visit the property or may wish to coordinate repairs. However, no direct communication is permitted to the owner regarding any matters for your lease, for repairs, or any issues regarding your occupancy at the home. The owner has entered into a separate management agreement with us, which we maintain on file here in the office, and the owner has also been given specific instruction that communication with the tenant is prohibited other than coordinating for repairs or potentially seeing the property. If there are additional terms to this lease, it is within section 43. Please review that now. Okay, this concludes the lease agreement presentation. If you will, please now notify the leasing agent that you are ready to sign the lease. Do not sign anything just yet until the leasing agent comes back in and goes over that section with you. And of course, if you have any questions, speak with the leasing agent now before you sign anything within the lease agreement.